So Sheldon, I want to turn to you for this. Many employers have made or are contemplating permanent staff reductions since the onset of COVID in March 2020. And these employers are wondering how the pandemic will impact employee termination entitlements. So Sheldon, since the onset of the pandemic, how has the law been trending with respect to common law notice entitlements?
Well, Seth, because of the pandemic's impact on the economy, notice periods has been one of the hottest topics. As many of you know at this stage, during the pandemic, there was a major development and a very controversial decision issued by the Ontario Court of Appeal in the Waxdale decision. The Waxdale decision essentially doubles down that termination clauses will be deemed unenforceable if they in any way violate the minimum entitlement that an employee should receive or could receive under the Employment Standards Act. Ultimately, Waxdale places a significant requirement on employers to ensure that their termination clauses in employment agreements are technically sound if they seek to rely on them. The Waxdale decision was not great news for many employers during the pandemic when many businesses had to reduce their workforces, and to their surprise, their termination clauses were unenforceable. This means that these employers are now subject to common law reasonable notice. Employers have been concerned because they assumed that notice periods would be high. However, in the decisions that have been issued to date, that is not necessarily the case. The first case is Hudson Bay, where an employee was dismissed before the pandemic started, and the court held that there should not be an increase to the notice period, even if the employee's reemployment efforts were challenged once the pandemic started. The second case is Peninsula, where the employee was let go near the beginning of the pandemic. Ultimately, since the pandemic was in the early stages, the courts determined that the future impact on the economy and the job market was unknown, and that the notice period should not be significantly enhanced as a result. However, in the most recent case of Marazato, which involved an employee whose employment was terminated later on in the pandemic, it was determined that the onus will be on the employee to prove that the pandemic impacted their ability to find alternative work. Ultimately, the best way for employers to avoid the unpredictability of notice period payment obligations is for employers to have their termination clauses reviewed and to ensure they are not surprised if they need to make staffing reductions either in the pandemic or in the future.